Welcome to Open Minds, a freedom of thought podcast series, interviewing the people who bring courage and independent thought to the challenges of today.
Well, welcome back. This is Todd Zywicki with Richard Epstein on the Freedom of Thought Project podcast, Free Thoughts. Richard, when we left off in part one, you had just taken up a faculty position at USC. Maybe if you want to tell us a few words about that. And then, of course, you're most associated with the University of Chicago.
Yeah.
So maybe tell us a little bit about your experience at USC and how it came about that you moved to Chicago.
Oh, sure. I mean, look, it's a kind of very interesting development. As I left off, I told you I had this interview with George Lefko, which lasted 2.5 hours. And he invited me out, and I go out there. And there's some very interesting things. I had a dinner with the House of Howard Miller. Howard was basically a faculty member at the University of Chicago who was co-editor-in-chief of the Law Review with Joe Sachs and so forth. They had a very bright little boy, 7 years old, and I still remember coming out of that saying, this kid's got a legal future. I said it at the time, and he's now was dean at the University of Arizona, right? And he was the editor-in-chief at the University of Chicago Law School, Mark Miller. That is, he was kind of like me.
Right.
That is, what happened is he was utterly fearless when it came to talking to adults, which is an extremely important attribute if you're going to become a future academic. So we talked about all this stuff, and I mentioned the situation about going to the topless bar. But the intellectual part of all this stuff was, I first met a man named William Bishon, who eventually could not stay in the teaching profession. But he taught a class, and the class was called Law, Language, and Ethics, and it was a philosophical class. And the man, what he did that was most conspicuous is the class was supposed to be over, and he kept it for 45 minutes extra. And I said to myself, trespass rules apply to time. And he didn't seem to understand that. And the whole thing seemed to be draped in an atmosphere of fear and so forth. And so what we did is we actually had this kind of serious confrontation. Now, the way in which this began as a teacher was slightly different. My first year, I was told by Dorothy Nelson, I'm going to do you a favor, she said. I'm going to let you teach the heaviest load on the faculty. And so my first semester, I taught a course in estate planning and a course in future interest.
Oh, wow.
And the second semester, I taught a course in corporations and civil procedure. And then I ran a legal writing section in my first year of teaching.
And this was doing you a favor, huh?
She was right.
Okay.
Because what happens is it really forced you to sit down and learn how to do very rapid class presentations and so forth. And also it forced you to figure out the potential connections that you have between different kinds of classes.
Right.
And the first class I had in estate planning, it turned out one of my students, her name was Bridget Troy, I believe. She had a husband who was working in a practice firm, and they had some kind of difficult problem. And so I got my first consulting job through one of my students on some difficulties. And then I got another one at Irell and Manila, and the client was Gracie Burns, that's Gracie Allen.
Yeah.
And what everybody said about her is that she was chaotic in her real life as she was on the television. She only played herself. And, you could see some of the problems then. And so this was extremely important because what it reminded me is that in order to be a decent academic, you not only have to have theories that work in the sky, but you have to have translation mechanisms that work to get them down so that they can give you answer in decided cases, or at least explain what the trade-off is when there are two kinds of uncertainty on how they go. And what had happened with all the philosophical stuff is that everybody would say, well, this is a very difficult problem and leave off, and that just is not good enough for a lawyer. And then once you start having to have right answers, you have to have wrong answers, then you have to have a kind of a theory to do it. So at that time, I was much more of a strict libertarian than now, and I could tell you in retrospect why. My English education was essentially a 19th century laissez-faire common law tradition. And the subjects that you covered were property, contracts, and torts. And most of them were 2, maybe 3-party situations. So the most complicated you could get would be a third-party beneficiary action. You didn't do any labor law. You didn't do any natural resources law. You never did anything in which there turned out to be bankruptcy, for example, a collective action problem of a serious magnitude. So essentially, the libertarian principles work remarkably well for the most part in those areas.
While you were at USC is when you wrote your famous article on strict liability?
Well, I was actually in transition from USC to think. So what happens is you start with all of this stuff, and then you say, oh, it just is not quite right. And what I first did was I had to develop out the libertarian side of the theory. But then fairly quickly thereafter, I said, now what's wrong with this? Because one of the things
your strict liability work would be more libertarian.
Yes. Well, and still correct, I think. But what it was explicate what we mean by force and fraud, which is a libertarian notion. And the dominant one was, of course, force. And so what happened is, given the categorization that I had coming out of Roman law, what they did is they had essentially a line between corpora corpore, that in English means by the body, to the body. It's kind of physicalism, realism, which dominated Roman law until they rose into a series of cases called causa mortis praestare, which means furnishing a cause of action, right, or cause of harm. Well, you have to figure out what that line is. And I had never taken the Roman law of torts at Oxford, but I read it, and essentially what happens is casuistic and so forth. So it tied in pretty well with the stuff that you learned in Heart and Honor, right? And so you kind of work that stuff out, and you have to figure out what I call the paradigms. Remember the four of them. They hold up pretty well in terms of what's going on. It turns out that the first of them is you hit me. And somebody says, how could that possibly be a theory of liability? It's just too simple-minded. Right. Well, it turns out it was too simple-minded, but for reasons that nobody pointed out at the time, which is you could hit somebody, and what you could do is you could make a sculpture, or you could break a sculpture, right?
Right.
And so what happens is the question is, what's the value of the physical change that's introduced? The causation theory is identical, or whether you're making the sculpture or breaking the sculpture. What you had to do is to invoke into this a notion of harm. And the question of harm has to be socially determined. And so you have to start doing evaluation with respect to the changes. Now, this sounds metaphysical, but if somebody makes a Rodin and somebody else breaks the Rodin, all of a sudden we know what the valuation question is going to look like. And so what I did in the early cases, I just buried the valuation question without doing it explicitly. Once you do it explicitly, then also the law of restitution becomes much more apparent and so forth, and the law of contract. And what I did is I didn't answer it, but I didn't make any mistake. I just wasn't explicit on the point. And then the question is how you go out. So the basic logic of my theory is doing the Roman stuff. It became very clear that what they did is they started with corpora corpore, that is by the body, to the body, and then they would try to go back a little bit further and see how far they went before the chain broke. And that's why they had the theory of causal intervention, novus actus interveniens, which literally meant new and intervening act. The American principle was but for, going at the opposite end, right? And trying to shorten it. Yep. So the question of which of these two approaches was right. And I came to the very emphatic conclusion by looking at both the Roman and the early English cases that the Romans had it right and we had it wrong. So that was essentially what the transformation was compared to the traditional reason. And it wasn't something, by the way, that Heart and Honor picked up. They were skeptical, but Honore was a Roman lawyer, but somehow they never put it all together. And so you start doing it, and then you go through the intermediate cases. And so the interesting one, for example, is you hit somebody, he falls off a pier, he thrashes around the water and dies. And so the question is, did you kill him or did he drown by himself?
Right.
And now you know what the right answer is in terms of liability is. You got to hold that guy responsible. So then what do you do with the intervening act? And well, you come to your first conclusion. Something is not going to count as a causal intervention if it's an action that somebody's doing trying to save himself and therefore to limit potential liability that you might have to him. And so what happens is those cases come out under the statute. But then the next case that comes out, I'm skipping a lot of stuff, in the interim, is the poison case, in which what you do is you start the casuist. The first case you have is you have somebody sitting there and you have some poison and you force it down his throat. And is that direct harm or an indirect harm? Most people would say that it's kind of direct and so forth. But then what you do is you put the poison in front of him. And so the question is, what is the liability when he drinks? Now, all of a sudden, mental states start to become extremely acute. And so the first thing is you put it in front of him, and he knows exactly what it is, and he decides to drink it. Does that become novus actus interveniens on the grounds that it's a voluntary act? And then you start looking around, was there any other kinds of conditions that might compromise that? And at least in some cases, the answer is no. So then what you have to do is you have to switch to two other cases. And it turns out these are Aristotelian cases that Aristotle never connected with causation. And one of them is you lied to him, right? So now if you do an act under mistake induced by a defendant, it turns out that we treat the responsibility as lying with the defendant, notwithstanding the intervenient act. And so, but we can't say you poisoned him in the strict physical sense, so we have an action on the case, which is based on the specialized facts associated with the mistake. And then you do the same thing with respect to coercion. And sure enough, if you go back to standard philosophical theories on that, you always have a real question of intervention when either mistake, right, or coercion takes place between whatever a defendant had done and whatever happens afterwards. That doesn't break it, but the other stuff does. And then you're off to the races on how it goes. Well, then there are going to be other kinds of cases. The English language, by the way, has something known as a hypertransitive. I guarantee you've never heard the phrase.
I've not.
And you don't know what it means.
I do not.
Yeah, but you use it correctly every day of your life.
I hope so.
Well, but essentially, is I made him go do that. Is
right.
What, so what's interesting about the hypertransitive is the middle person is both a recipient of an action by the ultimate authority and an actor independently of himself. And so then the question is, can you go after the first guy if the second guy has been coerced? And the answer is always second. Yes. The hard question is, can you go after the middle guy and give him an action over, or do you treat the dominance of the first guy as essentially saying that he's no longer an act?
Right.
And it turns out the English cases were right on that. They said it's not a defense, it's not a denial. It's essentially a right for an action over. The denial would be in the other variation where you have somebody and you take his arm by force and strike another. At that point, it's non actio, that is, he did nothing. So all of a sudden, you're starting to draw lines between actions done under duress and actions not done at all. That has its contract equivalent and known as factum, right? I didn't do it, as opposed to doing it under duress. So doing the incremental stuff was extremely important to figure out how you put this theory together.
Right, and
it worked.
Right, and you were saying that this is where you started seeing the limitations of libertarian theory was in terms of multi-party issues, but also you had indicated, and your example here is consistent with that abstract libertarian theory doesn't give you ways of parsing among these these very similar fact situations.
Well, actually, that gets the difference. No, the libertarian theory works on the causation and the creation of dangerous conditions, where what you do is you put the poison in front of him. You don't say anything one way or another. It looks from the appearance that it's safe, and you drink it. And what happens is the causal chain is not broken. And the constant objection that was always raised was that if you have in dangerous conditions, then there's going to be no limitations on the causal chain. So then what you have to do is to give other type situations. And one of the key cases on that was Rylance and Fletcher. Yep. Keep something on your land which is likely to do mischief if it escapes. You're responsible. But you go back to the original case, and it turns out it's a causal battle. So there were two justices, one of them Bramwell. What he did is he looked at the situation and he said, what you really did in this case was you poured water into a well and it damaged somebody else. And pouring is essentially a direct act because the gravity that's involved in this is not an independent cause under any case. Otherwise, nobody would be responsible for anything. And then there was a judge named Martin. And when he said no, what you really did is you poured the water into the reservoir and it remained stable, and then it broke. So it's an indirect case. And you look at the heading of the case, and they said it was trespass. But Martin said no on the other thing. And so what you then had to do is to say, why is it that both men were right? And what happens is it turns out water has very distinctive features in causation, which neither of these guys grabbed. But when you put water into a well, some of it's stable, and some of it's coming in, right? And so the stuff that's already there is released when the new water comes in. So that turns out to be an action on the case for indirect harm.
Right.
But the water that's poured in immediately that drops, it's a trespass bottle of water. And so what happens is when you're dealing with water, you get two of these things in an amalgam form, which is why it's such a distinctive problem. And in the end, what happened is Blackburn makes an argument saying somebody who keeps and collects something on his land which is likely to do mischief if it escapes, he picks the second argument, but he ignores the first. And so the instability in the causation theory is like that. And then there was the liability problem, which we mentioned, that Hart got wrong. Everything he said about causation was to some extent wedded to negligence. Now, why did he do this? Well, you got to know the intellectual climate in England. He wrote the book in 1959 with Honoré. The dominant theories were developed by people like Glanville Williams and Arthur Lehman Goodhart, and they were all negligence theorists through and through. That is, every time you gave a strict liability case, they didn't like it, so they throw in res ipsa loquitur to defend.
Right.
So they had no theory of causation that's tied to strict liability. So you can never say you hit me as a tort, even if you did. What you have to say is you hit him, and you should have done something to prevent it.
Right.
But that's the wrong theory.
Right.
And the most famous case was a 1951 case called Bolton and Stone. I don't know if you remember this case.
I do not.
Well, Bolton and Stone is a case about a cricket ball.
Oh, this is the cricket ball.
Yes,
Okay.
and this is 1947
I
that
remember
happened.
this from your article.
Yes, and it goes back to, but it's a case which I mentioned because to my mind at the time, it was just absolutely dispositive of everything what was wrong with the English system of jurisprudence when I finally figured it out. Well, the first thing you have to do is to know something about cricket. And what you have to know about cricket is a good cricket player rarely hits a ball on the fly because it's too likely to be caught. And they have outs and runs in cricket like they do in baseball, but the ratios are completely different. In baseball, if you could get a run per an out, you have the greatest baseball team in the history of the world. 27 runs a game, right? Nobody's going to beat you. In cricket, if you have a score of 21 after 10 rounds, you're the worst cricket player in the world. So a typical cricket player is trying to get a score, a century if he can do it, but certainly in the 50s and 60s, before you get an out. So the optimal strategy is to keep the ball on the ground. So anything that goes in the air is kind of an amateur. So in this case, this guy hauled off and he hit a six. That is a ball in the air, and it hit Miss Miss Stone standing on the street. It wasn't in her lawn. It wasn't on private property. And she gets conked on the head. And what happened is the English courts managed to find more ways in which she is unable to recover from everybody because they had a negligence theory. Right. So just hitting was not enough. And then the question, well, who's responsible? Was it the pitcher who threw the ball in the wrong way? Was it the cricket club for putting the pitch in the wrong place? Was it the cricket club for not raising the fence? Did it make a difference that it was the home team, rather a visiting batter instead of a home batter? They had all sorts of questions that they couldn't figure out. And what you really needed to do is to start over. And what do you start over? You say, first of all, he hit me, right? And we talk about the harm, non-harm. Well, this is a clear harm case. And then what's the defense? Well, can you use assumption of risk? Well, not if she has a right to be there.
Right.
Okay, can you use contributory negligence? Well, she didn't see the ball coming, couldn't have done nothing to avoid it. So it turns out you get no defenses whatsoever. And so the case just stands. But if you choose the English view, and you have to find some reasonable probability that you knew about something and could have prevented it, you have this great battle. Is it enough that you hit 6 cricket balls in the previous 100 years that went into Miss Jewison's garden or things like that? Everything that was irrelevant became decisive.
Right.
And so I said, look, what you have to do is start over.
Right.
First, what you do is you get the strict liability. But then you have 2 other areas that you must add in, which are non-causal. What you have to do is to say, you're an occupier of the premises, and generally speaking, you are liable for the harms that are committed by people on your premises with your permission and blessing. So you use a vicarious liability theory rather than a causation theory to get the club, which gives you the institutional response you want. Or you could say you go after the visiting team. Well, at this point, you have to ask the question, is hitting a cricket ball on a pitch within the scope of employment? This is not a killer question, right? It's perfectly obvious. So you get to both clubs. Well, then what do you do institutionally if they're both liable? Well, first of all, the case becomes easy, right? Summary judgment. And you know what everybody does in cricket. you get these two defendants, and they form a defense and recovery agreement.
Right.
And through the league, and what they essentially decide is everybody carries the insurance for liability and tort on the home field, so as to make sure you get a single defendant that's solvent with respect to it. End of problem. Well, this is a complete difference, right? Like an absolute upside down turning. And what was wrong with the standard view is that they try to make everything turn on causation and nothing turn on vicarious liability.
Right.
And they just got it wrong. I mean, up and down the line, there wasn't a single judge who got anything right with respect to it. So you say to yourself, how could you get a simple case like that wrong? And it's very easy, as it turns out, because what happens is the moment you commit yourself, as Hart and Honore did, to a kind of a negligence theory, what happens is you have to find something that could have either avoided or prevented the harm. The easy cases, we have to avoid or prevent harm that you cause. And the hard cases, if you're the club, the home club, you have to prevent the harm caused by another individual. And it just doesn't work. And so this was all straight libertarian kind of theory.
Right.
The problem you start getting when you start getting to nuisance cases is it breaks down. And so the famous case is Bamford against Turnley. And this is ironic. The single most astute person on the limitations of libertarian theory in England was Baron Bramwell, who was an ardent libertarian. But what happened is he just had a tremendous...
Tell us about Baron Bramwell. Are we talking about 19th century, 20th century?
Baron Bramwell was born, 1808 and died in 1894.
Okay.
And he ended up on the House of Lords. He had been a very distinguished lawyer and practitioner. And in the 1850s, he was appointed to the bench. And in 1862, he had a very simple case, which turns out to be profoundly difficult. It was a nuisance case. Already you're kind of moving out there. And what happens is you have somebody setting large fires on somebody else's property that go there. And he says liability, and it's strict. But then he gave the following question, and he becomes a Parisian. He says, look, suppose you have two people who are neighbors, and you set a little small fire on your land and some smoke goes into somebody else's eye, and he does the same thing to you. He says, if you have reciprocal low-level nuisances, a law of live and let live is better than a rule of liability with damages to follow. So what's he doing? What he's saying, in effect, is I can get a Pareto improvement over the common law distributions under the negligence theory by essentially sparing both parties reciprocal liabilities from the other.
Right.
And he was right about that. So here you get this common lawyer, and essentially he's so close to the Parisian formula for a general social improvement that you just have to tip the needle a little bit, and you realize he's absolutely into that stuff. So what happens is the reason why Bamford and Turnley is such an important case is that when you finally unpack the reason why it is low-level nuisances are different from high-level nuisances, you can't use a libertarian theory, because in a libertarian theory, the invasion that matters and everything on its extent simply goes to damages. And here you're treating it as a set of reciprocal defenses. So the world is transformed. Because if you do it there, then the question is, how many other cases can you find this out? And the basic intuition is this starts off as a two-person problem. But by the time I wrote about this systematically in my nuisance article in 1979, I mean, I've been stewing about this for a very long time, but I could never quite get it. What happens is you realize that if you're playing the reciprocal game, automobile pollution is fair game. But then, of course, the question is, how is it fair game? Well, first of all, you start with a live and let live rule, right? You do it and I do. I lived in Los Angeles at that time, and I can assure you the way in which value was determined in 1968 was how far were you from the Pacific Ocean. And the further you were from the Pacific Ocean, the less value the land had, because the pollution was simply so bad that if you're in San Marino, your lungs ached every time you walked outside. It was that bad. All right, so what's going on is, yes, you got live and let live, and you got average reciprocal harm. But if you then go a little bit further, you find that everybody's worse off than they were before, because it's not the kind of conditions you have in the backyard.
Right.
So what do you do? Well, you can't have private right of action, but now you have a case for public regulation.
Right.
Which essentially is a device to limit the amount of pollution that comes at the pipe.
And this is where the libertarian theory breaks down.
Yes, and it was on that issue. And then the question is, well, how far do you go? And since the de minimis cases that you had in ordinary cases, what happens is the baseline for this is you never hope to reduce pollution in these cases to zero. What you try to reduce it is to a average sustained level so that for everybody under the system, the greater freedom to drive cars offsets the residual harm that applies. Well, then you have to transfer this into the public space, right? And now, what are you going to do if you're the EPA? And the key element to understand about this is a causation element, which is what you need the government for.
Now, if this were you influenced by Coase at this point?
Oh God! It turns out the man kind of took over my mind.
Right.
Because all of a sudden, every time you found an anomaly.
Because at the end of our first part of the podcast, you said you
I never heard
dinner
of him.
And you never heard of this guy Coase.
But what happens is, I came to it in an odd way. I mean, by this time I was at Chicago. I was a good friend of Ronald. We were always good friends.
So you moved to Chicago when?
I moved to Chicago in 1972.
Right.
And what Ronald did was, it was an interesting time. He and Dick Posner were at war with one another on many issues.
Really?
Oh, yes. That's why we had the Journal of Legal Studies, because Ronald was interested in the way in which the legal system influences the operation of the economic system, and Dick said, I'm interested in the way in which we formulate legal rules. And this was, to me, they were very much alive. And there's a story about them. I was not in the room at the time, but it was told the two of them actually have a kind of face-to-face confrontation. And what Dick does is he looks to Ronald when he forms his new journal. I was in the first issue, right, 1972, and then I published my unconscionability article with Ronald, who was a great believer in it. And what happens is Dick said, I thought, Ronald, you believed in competition. You know what the Coase answer was? It's still the most devastating answer I've ever heard. Competition, yes. A fifth column, no. Ronald was a great wit. And I mean, the two of it got really serious. So one day I was standing outside the elevator and Ronald comes along, and we were always good friends. I think I was probably his last close friend at the University of Chicago. And, we last had our lunch in 2012, just before he died. Right. And Ronald comes looking at me and he says, I've been a failure. I said, really, Ronald? He says, nobody understands me. I said, Ronald, if your name becomes an adjective, you're a success. That's the first thing I did. And then I told him something which he never quite got. He misunderstood his own theory.
Oh, really?
100% misunderstood. But let's go back to the nuisance stuff, and you can see how it links together.
Right.
So essentially what happens is, if you're a Coasean, and you have a system of rights which you like as efficient, and you know that it's not enforceable, the major transformation you have is collective enforcement without any transformation of the social norms. Right? So that means, in fact, if you had a live and let live rule, and you had this, you can do that much but no more, when you put the environmental stuff into place, it's exactly the same thing. All of the environmental rules that talk about zero this and zero that are, if you're a Coasean, this is just crazy.
Right.
Because what happens is you're now in the point where the costs are going up astronomically and the benefits are going to be somewhat trivial. Right. So follow what the older system was and play it that way. And don't ever change the substantive norm by virtue of the fact that you're forced to have a collective resolution of the project. Right. That becomes the real baseline. And so all the stuff in the environmental law that deviates from that is essentially persona non grata in this universe. Now, why is it that I say Ronald did not quite get all of this stuff? The larger theorem of which this is a special application, if there are high transactions costs that bar a voluntary solution from which everybody benefits, you can think of a regulatory scheme that creates a Pareto improvement of what you have. And so that explains why you have cash limitations in common pool situations and so forth. Ronald's view was he explained some very interesting nuisance cases that had to do with disputes between neighbors. And the most famous of them is a case called Sturgis and Bridgman, if you remember it. And this was a case in which you had somebody who essentially ran a doctor's practice, and somebody else who ran a sort of manufacturing practice. The manufacturing guy got there first and made a lot of noise. And then the other guy comes forward and he comes next to him. And the question is, how do you do the causal questions between the two of them? Now, if you go back and you read Baxter and Altry, you remember? That Baxter and Altry was Lillian Bevere in her first name. And they get it completely wrong. They kind of think about, well, you start with the first guy there, and the second guy, you got a huge assumption of risk question that you can't get around. And so they have to make all the adjustments rather than the first guy. Lord Jessel was much smarter. He was a genius. This case was decided around 1879. And the first thing you note when you look at the Jessel formulation is that the case is about the statute of limitations. Now you say to yourself, why the statute of limitations, right? It doesn't appear you recall at all in the Altry and Baxter article, does it? I don't know.
Right.
Well, it would happen like this. What he does is, the guy, Jessel, says it, I'm looking at the situation from the ex-ante perspective. And the first thing I see is that nobody's doing anything. And then one guy comes and he builds something, and he creates a situation where fumes and noise goes across the boundary line. But he says nobody's been hurt. So this is what I'm going to do. I'm going to allow him to do this, but as a quid pro quo, I'm going to toll the statute of limitations, because if I don't toll it, then you're harming somebody else's land, is going to run the statute so they can immediately sue to shut you down. We don't need that.
Right.
So we'll do this. Then the moment there's an actual conflict that starts to arise, then the statute of limitation comes in. But you always have enough time so that essentially what you do is you give the defendant a little bit of leeway so they could take an orderly disposition of their activities before the plaintiff resumes his. So if you start then figuring out what the total maximum is in the two periods, what you do is you get the maximum in the first period, which you won't get if you use the common law rule, and you get the maximum in the second period, because almost invariably in these cases, sensitive uses of an industrial nature are much more valuable than these crude uses associated with smelting and so forth. So he got it right.
Right.
Because what he did is he understood that you have to break this thing down, and you just can't treat it as a simple assumption of risk case. So how does the common law do with it? The judges in the restatement, it's an assumption of risk case, but they can't figure out a per se answer. So it sends on the facts and circumstances. Well, that's always a sign that you don't know what you're talking about, because you have to indicate what fact and what circumstances and how you do it. So he got it all right. And that's what really impressed Ronald. And there was another case called Robertson and Kilbert, I think it was. Really interesting case. You have a factory, and the guy next to you has a party wall. And what happens is the smoke comes out, it bounces off your wall, his wall, and comes back into your property. And so the question is that, or is that a nuisance, and so forth. So he went through all these variations. So what Ronald thought the whole problem was about was using high transactions cost analysis to deal with complicated nuisance cases. And so I remember telling him once, I said, Ronald, you get a corporation situation and so forth, and you got a lot of difficulties as to how you allocate assets amongst various individuals and so forth. Why do you put in various classes of stock? So much of what you're doing is designing institutional arrangements so as to minimize transactions costs by creating a central standardized interest out of non-standardized interest. Now, what do you know when this process begins? Guess what? It's always the same answer.
Roman law.
Of course. Right? And so what you do is you go back and you read the Roman law stuff on this, and they essentially say when you have a partnership, you have an undivided interest in each of the physical assets that are part of the plan, as opposed to owning a particular piece of each and every one of them. And they want to do that so essentially that when you start to deal with the partnership interest, you lower the transactions cost by using the interest which is placed on top of the asset, which is, of course, the same theory with respect to corporations and everything else. It all tends to go back. And Ronald never got that. Now, why didn't he get it? It wasn't because he wasn't smart. In fact, he wrote this theory of a firm, right?
Right.
What it was is Ronald never had sufficient experience with the underlying substantive facts that would let him pick up anomalies in something. So go back to his other great article on the nature of the firm. It's a great article, right? But it's also deeply wrong. Now, why is it wrong? What Ronald simply said is that we have a situation where relational contracts reduce transactions cost relative to spot transactions. So we firm a form and we start having wages instead of individual payments and so forth. Okay, but then when I wrote a little piece about it, I said, okay, look at Ronald and ask the next question. What's the structure of that firm? Is it a partnership? Limited partnership? Or do they have employees?
Right.
What happens is he got the basic question right, but he never applied the institution to figure out what kind of arrangements you want to have and why. So you start seeing these contractual arrangements. You do antitrust law, as do I, and you realize if you understand what the deal is, things that may look to be exclusive turn out to be efficient. And so the whole point of getting the transactions cost right on the structure of these organizations is to allow you to figure out the efficiency versus restrictive trade. And there's some cases that are mixtures, some that are clear one way or the other. But unless you could be very sensitive to how these firms are put together, you can't do it. And then, of course, it also has to do with the succession issues. There's a section in the Internal Revenue Code called 7701. And what's it about is what happens when one partner dies. And everybody has to do it, right? And what they desperately want to do is to make sure that the transaction takes place without undue tax burdens.
Right.
And so what they do is they essentially do not say that every one of the old partners who goes into the new partnership has disposed of his old interest, has to pay taxes on them, and then they get a higher basis. So what you do is you find a way in which they could buy out the outsider, pay him off, and then change the basis of everything else without having to recognize gain.
Right.
It's the same point again, right? You have this, and then we just had this wealth tax stuff, right? Well, what's Eisner and McCumber about? It's the same problem. You remember the case?
Yes.
Well, for the audience who doesn't, you have this company, Standard Oil, I think it was. It was interesting. It moved from New Jersey to Delaware and so forth, and then they recapped. And this was because of the Wilson stuff and on anti-corporation. And they do a 3-to-2 stock split. And the question, is it income or is it not income, right? And if you start looking at this from a transactional point of view, you ask yourself, why on earth would you want to impose a tax when what you've done is you take a share certificate, which was worth X, and now make it 0.67X and give people perfect compensation on the other? So if you go back to the standard definition, the Haig-Simons definition, Haig did not understand what the definition required. It turns out that when you do the recapitalization, there's no gain or loss, right? It's just changes in the paper. So the tax should be zero. What this man thought was that you should tax the appreciation that took place during the previous 6 years, which you would have never done. And so what happens to the Internal Revenue Code? Well, what you do is you put in the reorganization provisions and you sanctify the result that they reached in that case because you understood what was going on, which is you do not impose a tax on something which disrupts the use of productive assets, requiring people to enter in very complicated transactions to pay the law. And the same thing happened in the most recent case. Everybody got it wrong.
I don't.
You don't want to go further.
Yeah, right. I don't want to run out of time, but I would like to hear. At this point, you said you moved to Chicago in '72.
Yes.
Posner's there. Coase is there already.
And Stigler and Becker
are already around.
And Friedman is all there, right? So you go into the law and economics workshop.
And so all the economists were coming. The law and economics.
It was a one workshop to about 1974.
Right.
And these were all powerhouse guys.
No kidding.
But they were all, in some ways, they were all subject to blinders. I mean, it was interesting. It didn't come to me at that time. I was sufficiently in the back of the room to watch them. But as you started, when you went back later and you started to figure out how it is that their various theories of regulation work, I've already told you that the Coasian stuff ran into difficulties because he didn't know enough about it to figure out how it operated. If you go back to Stigler, he wrote his famous piece on regulation and capture in 1962 or so, right?
Yep.
And what he never understood was he was at the dawn of a new era in which the regulators were not going to be the railroads who could manipulate what was going on. These were going to be environmental claims in similar situations by outsiders. And the idea that the inside parties could always win has been falsified so many times. When you start talking about environmental regulation, which has both its good and its bad side, for the reasons I kind of mentioned and so forth. Becker, in fact, when he started to talk about crime and punishment and so forth, he was very insensitive to some of the institutional arrangements. Why is that? If you remember, his theory was you could economize on administrative costs if you put all the burden on a single guy, right? Because you have only one law school. So when you have parking tickets, what you do is you pick out one guy who has a parking ticket and subject him death by by torture, right? And that will solve the problem. Right. All right. Well, then you start doing this. You say, well, which guy do you pick out, right? When there's 500, well, why not pick out your political enemy, and so forth, or why not trap somebody into this so that you could get after him? And all of a sudden, you realize that small fines, essentially proportionate to the offense, have a kind of institutional stability that prevent those kinds of massive abuses to which Gary was not particularly sensitive. He also made real blunders. He wrote a paper called Theory of Social Interactions. I don't know if you're familiar with it. It's the Rotten Kid Theorem paper, which he says the way in which a parent disciplines two children is he tells the first kid, if you do something terrible, I'm going to really give everything to the other kid. And so each of you are going to stay in line even if you don't care about each other. He gave this at a workshop in 1977 at the Stanford Center for Advanced Studies. Ollie Williamson was there. And he asked Gary, he asked him the following question. He says, well, why not kill your sibling? The mechanism doesn't work there. Well, so what did Barry miss?
Right.
Well, he missed something that was critical. It turns out, if you know the biology, children actually have common genes with each other.
Right.
And so the idea that they're always enemies are wrong.
Right.
What you have to do is develop an equilibrium theory.
Right.
And it turns out if they have 50% overlapping genes, the cost of cooperation in most cases is pretty low. So and sons becomes a dominant form of operation. And if you go back to guess what body of law?
Roman law.
The first partnerships that you start to see are ergo non cito. They're
So
partnerships between children after the father dies, and they continue the business which they used to run under his supervision.
So you're at Chicago during this period, and more we see Friedman. A lot of these guys a lot more sort of getting involved in public policy. The government. Reagan comes along. Dick, Frank get judgeships. If you ever were you contacted or you were considered at that time to potentially
not immediately, but a little bit. Yeah,
I
mean, look, in 1984, the Heritage magazine ran this. Did I mention this to you already? I can't.
You have not.
Well, there were 4 people whom they put on their covers, potential Supreme Court judges, and Posner and Easterbrook were not amongst them.
Right.
There were guys named Scalia and Bork. And there was a guy
Scalia was at Chicago at this point, too.
Oh, no, he left in 1982 to become a court judge.
Oh, he left in 82.
Yeah, and then we had this famous debate.
And when was he on your faculty?
He was 77 to 82.
Okay, so about 5
And
years.
I was in the hiring committee when we brought him in.
Right.
And he was the only person I've ever interviewed who remained a partisan after he left government, just as when he was in it. It wasn't a bad cause. He essentially sort of wanted to talk about how it was that the president had to protect executive privilege against inquiring minds. Ted Olson died yesterday or so forth.
I did not know that.
A great man,
yeah,
as you
great
know.
Man.
And and he would defend that as though he was still in government.
Right.
But he went there, but this time the dominant issue in the 80s was how you make the transition from private to public law.
Yeah.
And I did that with my nuisance paper and stuff I told you. Most other people did not do it that way. They treated the common law as a kind of a sideshow, and the dominant principles were the scope of the police power and so forth.
And that's what's striking about looking at your intellectual career is that you've got this core set of principles that you said earlier, sort of 10 principles where you can deduce eight of them. And it seems like I'll put it this way. When I reverted to the Catholic faith, I was talking to my priest, and he was explaining the deposit of the faith, right? That you go back to these certain principles and you can constantly renew from those basic set of principles these new ideas. And so you're deducing your public law concepts from.
And let me explain how. The 2 missing pieces in the common law synthesis were taxation and eminent domain. Right? They just don't fit into that system. And you look around, is there any society that's ever run without taxes? No. Is there any society that's ever run without an eminent domain power?
Right.
No. So why is it you have a theory that you're completely persuaded is right when it can't explain 2 of the dominant institutions of your time? And so what you had to do is to work them into the system. And that's where all the stuff having to do with public takings for just compensation fit in. And that's the takings clause now tied very much to private law principles and extending out. And so what happens early on in the 1980s, I start developing all of this stuff as a kind of in articles of one kind or another. I did a very long one on the contracts clause, the revitalization of the contracts clause, which tried to explain how it was when you had some of these cases involving the statute of frauds, the issue is not that there was or was not an impairment. There was a clear situation where there was an impairment of contract, but it was justified because the statutes of frauds gave you ex ante benefits, licensing, and so forth. So you explain all of that stuff. And what all of a sudden happens is if you get it right, you get a very strong dominant view for flat taxations for general revenues, probably off consumption, but it would work less well, but well off of income. And then you have special taxes and special benefits. And the cases that came up later to sort of test this were Dolan and Nolan, the two famous cases about how you deal with somebody who wants to take land for a lateral.
Takings about 1984.
1985 was the year it came out.
Right.
And, there were some private reviews. My good friend, he was a friend named Joe Sachs. We had a conference in San Diego convened by Larry Alexander, who was a classmate of mine in law school, and kind of a defender of it. I
wrote a book review of that as an undergraduate student in a publication that no longer exists.
Yeah. You wrote a review of my takings book?
I did.
Well, thank you. I hope it was kind.
I'm sure it sold dozens of copies after I reviewed.
Joe Sachs wrote a review. He had read the view in draft, and his original version of the review was as follows. I read the first sentence. Like a shaggy dog, this book will tempt every passerby to give it a tick. It is devoid of logic, theory, interpretation, and history.
So glad I sent you the manuscript for a review. Huh?
I did.
I know. It's like learn that lesson.
I mean, oh my God, what is this about? Well, we had our show down at this conference in San Diego. Joe did not do very well. I mean, he's dead now 10 years, and we've had other debates since then. But I was really out for bear. And the rule at the Liberty Fund was that you had to stay for the whole conference to get paid. Joe left early.
Right.
And Joe was the only person who didn't allow his remarks to be put into the conference volume.
Wow.
And the way the conference volume goes, I won't talk about all of it, but there are two hardline libertarians who didn't believe in it at all. Everybody else was some kind of...
Where would we find this volume?
It's a Miami Law Review.
Miami Law Review, okay.
And, and there's an introductory essay there called The Malthusian Constitution by Tom Gray.
This must have been one of Henry Manny's.
I don't think it was Henry. This was Larry Alexander who did this at San Diego. And, I mean, it was just an extraordinary volume in terms of the intensity of the criticisms and so forth. I mean, Mark Hellman wrote one, said, well, this is a book for the crackpot press, vanity. Why did Harvard publish this thing? And the famous line at the end of his, Paul Bator has just gone to Chicago. Why would anyone want to go to a faculty which has Richard Epstein as one of its members? I mean, those are the kinds of things that were written about this book.
Right.
Well, all those reviews are long forgotten. Because what they constantly did is they said, we don't like the conclusion that the New Deal is unconstitutional. Right. And so therefore we think any way that you got there has to be wrong. But the way this goes, the hardline libertarians on the other side, and then at the end of this conference, what happens, Bruce Ackerman gives this long peroration in which he says, laissez-faire principles have always been tried and they've always failed. And I then start an answer and I say, but. And Larry Alexander calls time. So the students say they cut out the but. Right. And I said, that's the single most important word in this entire two-volume essay because it indicates I may be bloodied, but I'm unbound. I have a series of answers. And I don't want to give this guy quite literally the last word, right? And so we're over time, but essentially that way. I mean, let me just mention one other thing about my sort of intellectual development. When you have a general theory, what you let yourself be guided in what you do is a very strange mechanism. Somebody comes up to you and says, we'd like to hear your views on that. I say, I don't know anything about that. I said, well, figure something out. And what you never do is turn that invitation down.
Right.
You always try to figure it out. And Ed Meese was extremely kind to me. He says, I'd like to hear your views on the Commerce Clause, right?
Right.
And all of a sudden I write this article which tries to turn everything upside down.
Right.
And there are many other occasions in which that happens. So over the years, I've been extremely fortunate to essentially take this basic theory with the just compensation qualification, and then you have to add in something about redistribution. And it starts off with property contracts and torts. Then when it goes to constitutional law, it starts with takings and contracts, but then it gets extended to everything else. There was then a remark that was done by Seth Kramer saying the problem about Richard Epstein, he said in 1984, in the Pennsylvania Law Review is he doesn't understand the doctrine of unconstitutional conditions. To which my answer was, I've never heard of the doctrine of unconstitutional conditions. But I said he was absolutely right. And so I wrote a foreword to the Harvard Law Review in 1988 about unconstitutional conditions, that you have to rise to the bait.
Right.
And it turns out the only way you can understand that problem is to understand how efficiency analysis under the antitrust laws fundamentally differs from libertarian analysis. What's the simple point? I'll give it to you in the most naive form. Somebody brings a charge of cartelization against you, and you can say, look, every person who entered into this cartel on the other side consented to it.
Right.
So therefore nobody can challenge it because it's not force or fraud.
Right.
End of antitrust law. Well, nobody believes that.
Right.
Or at least except people believe in no antitrust law.
Right.
So what's the trap? The problem is that there is a reduction in consumer surplus.
Right.
And so what you have is a situation where you're better off entering into the contract. So you meet the libertarian requirement, but there's an extra element of surplus that you lose. And if you protect that, it turns out that you now protect social welfare because of the famous triangle, right?
Right.
So the argument turns out to be the only way you understand unconstitutional conditions is to abandon a libertarian framework and to use an antitrust analysis to see how it goes. So I'll give you just one simple example, and you can see, how it works. There is a rule which says, is consent the defense when you enter into a jurisdiction? And the first case is a case from Massachusetts in 1926. And what happened is you enter the state, and they used the Lockean argument, since you have now used our public highways, you hereby have consented to allow any action that involves an accident that takes place within our state to be litigated here. And the efficiency gains of that are obviously enormous, right?
Right.
Okay, well then you do the next case and say, anybody who wants to enter into our state hereby consents to have their divorce adjudicated under the laws of Massachusetts. So I said, what's the difference between the two cases? And there is no difference whatsoever if you're a hardline libertarian. On the other hand, if there's an efficiency arrangement, you then ask the following question. You drive in multiple states, and then you say, well, suppose we put the first condition in every state. It's perfectly stable, every state advantage, nobody's prejudiced. Now we have a rule which says, any state you drive into, you agree to allow them to adjudicate your divorce, your contract disputes. You now have to do it in 50 states?
Right.
Well, it's obviously there's a jurisdictional problem and an efficiency problem. You don't do it. And so what you need to do is to say that condition is inefficient. And once you say that, you have to figure out what a theory of efficiency is about. And so what you do in constitutional law is you follow the pattern in private law, which starts with libertarian stuff, and then contracts not to compete and so forth. You get the antitrust overlay. Public law has the identical parallelism. Once you understand that, as you move to other areas like intellectual property and so forth, which is obviously a state monopoly, all of this stuff starts to convene. So essentially, I've always thought that you want to be rational. You can't be rational with just one principle. We require at least two. And if we had another day, we would talk about the third problem, which is how you work redistribution into all this.
Right.
But enough is enough, I suppose.
We're running out of time. I have two final questions.
Okay.
One is, how many different courses have you actually taught? You've talked about administrative law, torts, contracts. How would you estimate how many courses?
It depends on how you break them down. So I've taught two torts courses different. I've taught about 40.
40 different courses.
Oh,
right?
But it's over 57 years.
Yeah, right.
And I always try to teach a new course, and they won't let me. Well, it's the only, you got to, look, if you don't move forward, you move backwards.
Right.
And I have another principle. Every time I teach a course, the second time I throw away my notes.
Oh, really?
Absolutely.
And do it again.
What?
Then do it again.
Well, because otherwise what you're going to do is basically you're not going to think about it.
Right.
So every year you have a different kind of trope that goes through the course.
Right.
And then as you start writing them up, you kind of remember, I talked about this. And then when you look at the cases, you could figure out where it was. It is very, very important in this business to be adventurous and you cannot be risk averse.
I was struck when you said earlier that you've never had a mentor, and you essentially recommended to young professors not to identify somebody as a mentor. I know we're going to have a lot of young professors? And
That's
people
the
want to be
problem of the
professors?
PhD.
Right. What would be your advice to young professors?
I say never get a PhD.
Never get a PhD.
Except for the hiring requirement.
Right.
And try to do something as a visiting fellow and essentially attach yourself to multiple people, but always have the core of your own being separate from them. What's really dangerous about the PhD, too, is it tends to silo you.
Yep.
And so you don't do the interconnections across fields, which is essential if you want to have a theory of law as opposed to a theory of corporate boards or something like that.
Right.
It's not that these are unimportant topics or you can't learn anything by being specific, but it's much more important to basically, if you can go across different areas, it's easier to learn the particulars within a given area by reading the established literature than it is to figure out the connections across areas where there's no established literature.
Do you feel like the legal academy today, I feel like it's become more siloed, more emphasis on people, you're the torts guy, you're the corporate guy, than when I broke into this business.
And more than I.
And sort of replicating the siloization of the rest of the
Look, when I was
university.
at Chicago or at USC, I told you my USC story.
Right.
The day I walk in, Dorothy says, you can teach everything. And then she keeps giving me different courses.
Right.
And I kept thanking her.
Right.
Because I figured out that she had gotten the right approach to this. It was a lot of work, but I was not married at the time. And so, okay, you're 25 once, you do it. And then what happens is, yes, it was right to do it that particular way. And then the other thing, when you're in an established institution, what you do is you teach a bunch of stable courses, but you teach seminars in areas which are, in fact, much more speculative and inventive.
Right.
And so that was the kind of thing that I did. And some courses sort of outgrow themselves. So I taught a course on FCC law in 1975, which was the era when the newspapers and the radios were starting to separate from one another, right? You can't teach that course now. It's just a different world. And so you either have to upgrade it or change it. And what you always do is you try to go to conferences. You always like to speak. But what I say is you go to conferences and somebody says it was a bad paper. Well, that's very common, but that's not the right question to ask. What did you learn when you thought about that bad paper?
Right.
And what can you add to your tool of tricks? And then if there's somebody who writes a good paper, it forces you to change it. So essentially what I used to say when I was younger, it still happens, but less frequently, I suppose, is every time you have an argument with somebody, sit back and reflect, what was the strongest point that they made and how could you incorporate it into your worldview?
I'm going to ask one final question that I have to ask because I saw it on Wikipedia. According to Wikipedia, Paul Reiser is your cousin.
Paul Reiser is my first cousin. He was born in March of 1956. So we're 13 years apart. My son Benjamin is in Los Angeles and is reasonably close to Paul. I was there. But let me sort of tell you about differential talents. Okay? Paul was born a comic and a musician. He's both. And so when he was about 4 or 5 years old, we'd come to our house for the Seder. And I would be home with my family, 61, 62, so forth, 60. And I'd play something at the piano. And Paul, when he was 5, would look at me. He said, you couldn't play that piece last year, and you can't play it this year.
His version of that was a bad paper.
No, but the point about it is the talent was so manifest.
Right.
So early. And then what happens is he gets out of Binghamton College, and Uncle Sammy wants him to go to Tulsa to run the Balanced Food Factory there. But he does an open mic performance in front of a guy named Earl Wilson, who was the Post columnist at the time. And it went well enough, and he never looked back. It was a classic illustration that if he'd taken the low-risk opportunity there, and then the other famous story about it, you would not know this, but I do. There was a movie called Diner, if you remember.
I remember Diner.
And he plays the moocher.
Yep.
Right? Now, how did he get that role? Well, I will tell you. He was in Los Angeles doing stand-up comics, and he has a friend who says, I'm going to interview for this particular role, which was to be the master of ceremonies at the wedding that takes place at the end. Will you come along and just hold my hand? And Paul says, sure. So he gets there and he sits down, and the casting director looks, and he points to Paul, and he says, you. I said, but my friend is here. You. Get on stage. So he gets on stage and gets the part. But what happens is they then decided that he was too good to have him only there. So remember, there's a character named Modell, which is Paul.
Right.
And what they do is they keep working him into some but not all of the schemes. So you're never quite sure whether it's 4 or 5. And that's all because of script revisions having taken place. And, you know, it was an amazing kind of thing that starts to happen. He did the Beverly Hills Cop stuff with Eddie Murphy, I guess, and so forth.
Right.
And he has a renaissance lately with Red Oaks and a bunch of other things. But Paul basically is just a very decent guy.
Well, there you go. Be a decent guy and figure out your talents.
Well,
Richard,
I mean, if he didn't figure it out, I would have told him.
There you go.
I mean, but it was so clear. And I did the same thing. My family, my father said, you'd be a fine physician. My father was a great physician. And so I'm going off to Oxford to study law. And my father's getting back about maybe you come back to medicine. And my mother says to him, she says, Byrne, dear, your son does not know how to hold a knife and a fork. What makes you think he will be a great surgeon?
There you go.
And that ended that.
Well, with that, Richard, it's been a thrill to speak with you. Thanks for spending the time with us on the podcast today. Thank you for all your advice, and personally, thank you for all you've done for me and so many of us who owe so much to you.
Wow.
You may not, you may say don't have a mentor, but a lot of us feel like you are a mentor. So
you
thank
always want to
for
have people whom you help.
Well, thank you. And we are trying to pass it on. Well, thank you for being with us today.